All right. Good morning, everyone. My name is Tom Avrutis. I'm an attorney with the law firm of Weltman, Weinberg, and Reese. And we're here to talk a little bit about Florida debtor-friendly laws, challenges for creditors. I'll just point out a couple things as we get started so we know going forward how to do a couple things. One is the first you'll see up there, if you have any questions, you're welcome to ask them. There's a question feature on your screen that you can just type that in and they would provide that to me. If I'm able to answer the question during the presentation, I will. If I can't, we'll do it toward the end, or we can answer the question later. Also, the webinar is being recorded, so if you want to get a copy of this later, you can. I want to welcome you to this. This is the 6th episode of Commercial Collections Corner, where we talk about all things commercial. And in this one, it's kind of interesting to me because you have areas of commercial law which are different than consumer, and then you have areas that overlap. The discussion that we'll be doing today pertains to exemptions. Exemptions only apply to individuals, and we'll be going through that. So it's more the type of thing that would apply to a personal guarantor in a commercial case. Before we get started also, I'd like to take a moment to just go over one or two more housekeeping issues. This is an interactive session, so your questions are welcome. And I don't mind a question while I'm chatting, whether it's on topic or even if it's on a slight related topic, that's perfectly fine. At the conclusion of the session, there will be a link to a recording and a copy of the presentation, and slides will be sent to all the attendees. Also, there'll be a quick survey on the screen at the conclusion, and I would ask, if you don't mind, if you would jump on that and just answer the survey. It helps us going forward with additional episodes. Also, I'll mention that we have another episode. The next one is coming up in August. I'm told it's going to be excellent. So there's another one coming up on commercial collections in the commercial area. All right, let's jump into this a little bit. Let's get right into the overview, which will be the next one. In the overview, I'll just mention to you, this is like a little table of contents of what we're going to talk about. We probably won't be able to get to all these things. I have a knack of writing too much and providing too much material, but the value to you is that whatever we don't cover, you can get a copy of this. You can get a copy of the PowerPoint presentation, but in addition, I wrote a separate presentation, which is a little bit more lengthy, a little more detailed, and it has the actual citations. So I know that what we have here are people at different levels. Sometimes we have attorneys that are familiar with a lot of this. Other times we might have people from a collection agency that have a general familiarity with the law of Florida, but not detailed. And then some are just lay people that don't really understand the details and don't practice law from day to day. So I'm going to try to talk on a mid-level, basically a beginner, but some of the points that we have in the webinar are a little bit more for intermediate toward the end. All right, so what you can see is the things we're going to cover are right here. The homestead exemption, the biggest exemption in Florida. And we'll talk about Social Security, 401k, wage earners, tenants by the entirety, a little bit about exemptions that pertain to garnished bank accounts, and that will help us lead into wages and what is a wage, unemployment benefits, IRS refunds. And then at the end, I don't know if we'll get to this or not, and this is the part that's a little more intermediate. It pertains to life insurance policies and annuities. We're not getting into that in any kind of detail, but it's important to know because sometimes as a collection lawyer, we run into people that have unique assets, like a life insurance policy with a cash buildup that maybe we can get to and maybe we can't. But the answer lies in the law. All right, so we'll move on to the first section then, which is the homestead exemption. The homestead exemption is the main exemption in Florida. It's the one that we're so well known for. People come from all around the country. They want to come down here and buy a house and know that their house is protected. And I say that because over the years, what we have is many people that have literally done that. They have moved from one state down to Florida because they want to protect their assets and they know that the big protection is homestead, and it is. What that means, and when I talk about an exemption just means that if we're trying to collect on a judgment, which is what we're all doing one way or another, and that judgment is against an individual, might be a personal guarantor or something, and that individual owns a home. In Florida, the home is protected, and we don't have any limits on that. The homestead exemption is sweeping. It's covered not just by statute, but by the Florida Constitution, which makes it very well rooted in Florida and not something that's easy to change. So we can expect the homestead exemption to be around for a long time. The homestead exemption shields the home from seizure. So if I have a case and it's against an individual and I have a judgment and they have a home that they live in, I cannot use that judgment to take their home or force the home to be sold at an auction. But in addition, I also cannot put a lien on that home. Now, I stress that a little bit because it's just surprising how many people get that wrong. And I don't just mean attorneys, judges also. And many clients, they think, well, just get the judgment out there and put a lien in the county on their home. So if they sell it, I'll get paid. Well, that doesn't necessarily work. Homes are just protected from liens and from forced sales. How do you get the homestead exemption? There's nothing to do. You don't have to file anything. As you can see, there's no registration. It's just automatic. But there are two requirements to have the homestead exemption. The homestead first must be your primary residence. And second, the owner must intend to live there permanently. It is at least something that must be their intention to have a permanent residence there. And you'd be surprised how many cases come up where that actually can be something that's challenged. We had one case, for instance, where we had an owner who had a home in Key West, nice home, lived there, and they had a judgment against them. They moved to California, got a car in California, registered their license in California, their water bills in California, and they rented the home in Key West. So the judgment creditor who had a judgment against that person filed a levy seeking the seizure and the forced sale of the home that was in Key West. And that became the subject of a rather substantial case. I share this with you because it's one of those extreme cases that gives you a feel for the homestead. The individual came in and said that her intention was to come back to that home sometime in the future. Well, you would think it'd be hard to prove that when you've moved all the way across the country, changed everything about yourself, where you live. It wouldn't look like there would be an intention, but the courts liberally construe all exemptions. They are liberally construed to favor the debtor and to protect the debtor. And in that case, the judge said, no, even though you've moved across the state, you've moved, you've rented your residence, it still will constitute your homestead, and they did not let the creditor put a lien on it or seize it. We see here also it's an exceptionally broad protection. It's liberally construed, and by broad, there's no limit. People can come here to Florida and buy a house with a $5 million and put all their cash into the house, and the house will be protected. When I first got this job, and by the way, I've been doing this a long time. This has been over 40 years, doing the same thing, creditors' rights in Florida. The person who hired me, his name was Jack Hodges, took me on his boat in Sarasota, Florida, and we were driving along the beach and the bay, and he was pointing out houses, and he would say, "Look at this house over there. Look how gorgeous that is, like a 5-story house on the beach." He said, "I've got a judgment against this guy, and I can't collect it because it's protected. The home is protected." And there was about 3 different houses that he pointed out to me. And what he was doing, he was educating me as a new attorney, reminding me that Florida is no easy place to collect, and we need to find exceptions in order to collect on judgments, and homes are exempt. All right, we can move on to the next. Okay, what does a homestead cover? If you are in the city, it covers 1/2 of an acre. If you're in the rural area, it covers up to 160 acres. So if you're out in the county somewhere and you have a home there, and then you have it surrounded by 160 acres, all of it is protected by the homestead exemption. No creditor with a judgment can put a lien on that property or take it. Next, you can see that there's only one homestead per debtor. And that comes up from time to time because often people will have a vacation home. And then the attorney has to make a decision. Okay, what can we take? Which home is the homestead? If they have a home and they're residing in it, and they have a vacation home somewhere, their principal residence will be protected. But if there's a second home, it won't be protected. And I have a case where I was attempting to collect from someone, and was sort of a very clever scenario because these debtors in Florida will get asset protection lawyers and get some good advice on how to protect their assets and how to not pay on their judgments. And I went after a woman who she had owned two homes. They were both in her name, but one she lived in, one she had her parents in. Well, when she saw that a judgment was coming down the pike, she did a very clever move. She sold both homes, knowing that if I got a judgment, I would be able to take the one that was not her homestead. So she sold both and then bought one house and then had her parents move in with her in the one house. And she still had a homestead and the protection of the homestead, which frustrated my ability to collect on the judgment. All right, next, protection generally survives the death of a debtor. Well, how could it survive the death of a debtor? It does because the house can pass to heirs. So if you have a $5 million judgment against an individual and they have a home and that's their only asset and they pass away, that asset can and will normally still pass to heirs, completely independent of the judgment or the judgment lien. And you can see there in this scenario here, judgment liens don't attach at all. There are some exceptions. There's some gray areas, but and we'll talk about it a little bit. But the general rule is that a home simply is exempt, and the judgment lien will not attach to it. What if the debtor sells their home? Okay, that happens plenty. If they sell the home, and we, as an attorney or the collection agent, is attempting to collect on a judgment, and the home is sold, they will normally have some proceeds. Those proceeds will continue to retain the cloak of exemption, just as the home did. But they have to be careful with those proceeds. There has to be an intention to reinvest those proceeds in a new house. If they do have that intention, and they take the proceeds and they put it in a separate account, so it's designated for a homestead or a new homestead for a period of time, and the cases there's a number of cases on it, but if it's about 18 months or so, plus or minus, the money will still be exempt. And the value of that to an attorney who's trying to collect is that we would want to monitor that account, because oftentimes they don't do that, or they don't do it well, or they violate it. And they go into the account and they start using it for personal purposes. And if they do, the account can lose the protection of the homestead, and the creditor may be able to get to it. All right, next page. Exceptions. Exception, the homestead exemption doesn't apply to prior recorded liens. So for instance, if somebody owns a home and there's a mortgage on it, obviously we can't go to the bank and say, hey, you can't take my house, you have a mortgage, it's my homestead. A mortgage is a voluntary lien. Any kind of voluntary lien is exempt from the forced sale. That's why banks have their mortgages, and they can foreclose on their mortgages independent of the homestead exemption. Mechanics liens, if somebody comes onto the property and improves it, puts on a new roof, they can put a lien on the home, and the homestead exemption will not help the debtor in that instance. Certain governmental liens, tax liens, can pierce the homestead. The next one, it says pre-existing judgments. This is sort of an interesting one, and I've discussed this topic with some of my friends who are collection lawyers. But essentially what it means is this: if there is a judgment out there and it's recorded in the public records in the county where the debtor lives, that constitutes a lien in that county. And if the debtor buys a house while the judgment is already out there and the lien is in place, the lien may end up attaching to the homestead because it's attaching at the very moment that they buy it, and it can constitute an exception. Next, partition actions. We don't see this a lot, but when two people own a home and they get in litigation between themselves and they want to have the house sold at an auction so that one or the other can receive their money from it, the homestead exemption won't apply. And then we have those that deal with fraud. Obviously, if a criminal goes out there and decides, okay, I'm going to rob a bank, I just stole $500,000, I'll buy a house. That's not going to work. They can buy the house, but it's not going to be exempt. The state attorney or the creditors can still come at it and take the house. Next, we have the Havico case. One of those things that you can't talk about homestead without talking about the Havico case. This is one of those cases that just tested the boundaries of Florida law as it pertains to homestead. In the Havico case, the short story is this. There was a guy, I believe he was in Tennessee, and he was being sued for $15 million for many years. When it came time for the judgment to come down and he saw that he was going to lose, he did what some people do. He moved to Florida and bought a home in Pensacola. It was about a $650,000 home. Then he waited a couple of years and filed bankruptcy. And he tried to say, this is my homestead, it's protected. So what the debtor wanted to do was scrape off and discharge a $15 million judgment, but still keep his home. And that produced a tough question for the bankruptcy court. They weren't sure what to do because this was really pushing the homestead so far as to really torment and abuse a creditor. So what they did was they said, we know the homestead exemption is rooted in Florida law. They sent it to the Supreme Court of Florida to make the decision and to decide. So the issue was this. If you have someone who, a judgment debtor, and this judgment debtor has money, and they intentionally purchase a home with a specific intent to avoid paying that judgment creditor, can the home still retain the cloak of exemption from forced sale? Or can the creditor in that case come in and put a lien on the home? It went to the Florida Supreme Court, and the answer is pretty basic. The answer is the house will not be exempt. The debtor got to keep the home. It was exempt, and you can actually buy a home and be running from your creditors at the same time, and it will work. Now, we have exceptions. You've seen some of those, but in the Havico case, it didn't fit an exception. And it's just one of those things why people like to come here and move. Like O.J. Simpson, that's why he came to Florida. He ended up buying a home. He lived here for his life, and he was fine during the time that he lived here. Nobody could take the home. The next two cases just deal with something we've really already talked about, and that is you cannot buy a home with money that was obtained from illegal activity. I'll point out one thing while we're chatting here also, which is this. If you want a copy of this seminar, I have the separate copy myself. It has all of the citations for these cases. So for attorneys, if you want citations to the cases, just email me and I'll be happy to send that to you. So the takeaway for creditors is homestead is difficult to penetrate. If they do sell the house and it goes into an escrow account, you want to look closely at it and then monitor that account. All right, we're done with homestead. Next, Social Security. All right, Social Security benefits. Here's the interesting thing about exemptions in Florida. It's not the kind of thing that always defeats the collection of a judgment, and there are exceptions. And the devil is always in the details. And surprisingly, many judges and even attorneys are used to hearing things like, well, Social Security is exempt. You can't take Social Security, or you can't take a life insurance policy, or you can't put a lien on jointly owned property. Well, that's the general rule. But the way to deal best with exemptions is, yes, you learn the general rule, but find out where the exceptions may lie. And this, so even Social Security has an exception, and a fairly significant one. I had a call years ago from an attorney, and he said he was trying to do some asset protection for his father. He said there was going to be a judgment coming down against his father, and he was trying to figure out how to protect his assets. And he started running through the assets that his father had. And the attorney, and this was an attorney, so he knew quite a bit about asset protection. But he said to me, he said, my father has a bank account. He has $130,000 in it. It's all Social Security. He's put every check in that account for years. He knows it's protected. So the attorney said, I know that's protected. Let's get on to something else. And I said, wait a minute. No, it's not protected. 3 months of Social Security is protected and not more. And not only that, those 3 months are only protected if the judgment debtor files an affidavit showing that he is using this money as a source, as an essential source of his ability to pay his bills. And what that means is this: if you have a case against someone who is, maybe they're retired and they're wealthy, or they have plenty of money or plenty of assets, but their Social Security is something that they're taking also, you can end up taking their Social Security because it is only exempt if it's only exempt up to 3 months and only exempt if they need it for their family support. So it's something you want to look close at. Next, practical limitations for a creditor. The exemption only applies to the 3 months window, which means it's just something we just need to trace and look closely at. All right, let's move on. We're doing good here. 401k and pension funds. Part of what we'll be talking about now is exceptions to the exemptions, depending on where the creditor's attorney, where the judgment creditor's attorney is trying to go to get the money. And the point here, I'll say it now, and you'll see it in the materials, is this: there's a difference between trying to seize an asset of a debtor when it's in the hands of the debtor, when it's in their bank account, versus when it's in the hands of a third-party entity. And what I mean is this: with 401k and pension funds, for instance, and even Social Security, we can't garnish the federal government and say, okay, we want to take their Social Security. The money has to be put into a bank account before there's even a shot at garnishing it. And the same with 401k and other pension funds. Those monies are not garnishable. In other words, we cannot freeze them at the source. And when I say at the source, I mean the 401k money is held, let's say, by an insurance company or held by a money market company. You can't send a writ to them and freeze the money. So that's just covered by Florida law, and that's the main exemption of these monies, that we cannot exempt it there or freeze it there. But once the debtor takes the 401k money out, or takes his pension money out and receives his pension check and puts it into a bank account, you have a different scenario. And that scenario is different in many of these different types of assets as to whether the money or the assets are held by the debtor or put in their bank account, or whether the attorney is trying to get it at the source. So the point here, and as we go through, is that things are different, and the collection lawyer has a much better chance of collecting if they go after the asset once it's in a bank account. And that's the same with 401k and pension monies. They are exempt. You can't get them. However, when you put them in a bank account, there is law that has come out of the bankruptcy courts in Florida. I haven't seen it in the state courts, but I've seen it in the bankruptcy courts that says 401k and pension monies are not exempt once they go into a bank account. So this broad sweeping objection that all pension money and all funds are exempt is not necessarily true. However, just because we have those cases out there doesn't mean you're going to win every time. There are some judges that are so convinced that pension money should be exempt that they just aren't going to follow it anyway. And they may not follow the federal cases. But I've had judges that have followed it, and I've had judges that said, no, I'm not going to do it. But there is plenty of law that supports it. A way that a debtor can protect themselves if they do take 401k money is to, if they're going to take it, reinvest it into another account, it will still retain that cloak of exemption. So if they completely close out the account and put it in a new 401k, it will be exempt during that process. All right, next we're going to talk about garnishments a little bit and head of a household. or head of a family. All right, now what we're talking about is garnishments. One of the big exemptions in Florida is the head of a family exemption. And what we're talking about here is this. We'll just take an example. I'm an attorney. I represent a creditor, a bank. I have a judgment against an individual, and the individual hasn't paid, and I want to do some type of garnishment. We can do a wage garnishment, and we have a limitation on the wage garnishment. It's a federal limitation that we can take 25% of their net disposable income. But what happens is when you file that writ of garnishment and it's served on the employer, the debtor has 20 days to file what's called a claim of exemption. And basically that's a claim saying that my wages are should be exempt because I'm supporting a family. And we'll talk about that in the next section. But what is a head of a family is anybody who is providing more than 50% of the support for a dependent. That's just the short definition of what is a head of a family. And that hits a lot of people that we try to garnish. So it's a challenge. So if you have, for instance, a husband and a wife, and the husband is employed, and you seek a garnishment of his wages, he's going to file a claim of exemption and say, hey, I'm supporting a wife and or I'm supporting kids, in which case his wages will be exempt from garnishment. Now, the exemption is complete. You can't get any of their wages. The policy is in Florida is that they want people to have a home, have assets, be able to pay for their bills and not be put on the street. So they simply don't allow any of their wages to be taken. Now we face the same issue that we did with the 401k money. What happens if someone is getting paid from a job, a W-2 pay, and then they take the money and they put it into their bank account? You have a different rule that applies. And the rule is this: a judgment debtor can put up to 6 months of their pay into a bank account and it will be completely exempt. So whether it's a wage garnishment served on the employer or a bank garnishment that's served on the debtor's bank, you have a different outcome based on whether the debtor is a head of a family. All right. What happens often is that when we issue a wage garnishment, excuse me one second, we take a wage garnishment, a writ, serve it on the employer answers, files a piece of paper and says, yes, we're employing John Doe and we pay him $5,000 a month for his paycheck. The debtor then files a claim of exemption saying, I'm exempt because I'm supporting a dependent. Well, now we have what's a hearing on that. It goes before the court, a claim of exemption hearing. And as you can see under the section that says key rule, at that point, we're dealing with a couple of different questions. And I'll kind of put it this way, and that is, you have the debtor and they're employed, and if we freeze their bank account and the money is in their bank account, but it is their wages, there has to be a review of the bank records to figure out, did the money in the bank account actually come from wages? And the way to do that is to get copies of their bank records and go through it. But the point here is that on a wage garnishment was served on the employer, or a bank garnishment where you're looking at wages in a bank account, it is the obligation of the debtor to show that he is the head of a family, or that she is the head of a family, for that to take effect. But when it comes to the bank garnishments, not only does the debtor have to show he's the head of a family, he also has to trace the money in his bank account to wages. So both of those requirements must be met in order for the debtor to be able to protect his funds. And that comes up in a lot of ways. I mean, you'll have a bank account that we freeze, and there's $10,000, $15,000 in it. You get the bank records and look at them, and you see there's a lot going on. Maybe the debtor sold some things around his home and had some money. You've got all these expenses that are going out. You have monies that might be transferred here and there, and then you also have his wages. Depending on how complex that is, the outcome can come in different ways. That is, whoops. All right, hang on one second. I want to just plug this in, make sure I have enough power here. All right, I was just getting a warning. Okay, so the debtor has to trace the money in their bank account to their wages. The important point here for the lawyer is to just remember that the debtor has the requirement to show that the exemption is there. They have the burden of proof, not we as the judgment creditor. So if they cannot trace it, the money in their bank account to wages, then they're not going to be able to have that homestead exemption, because that exemption on their wages that go into their bank account. All right, let's go to the next page. Defining head of a family. We just talked about that. If 50% of the support is being paid by a judgment debtor to a dependent, then they are the head of a family, which would mean that their W-2 wages are exempt. There's a number of cases on this. The Holland case and also the Beckman case, those cases deal with kind of an interesting issue and sort of an exception to the rule, which is always what we're looking for. Every judgment creditor is looking for an exception to this head of a family exemption, and that's one of them. Sometimes we have scenarios where it's not clear. We have a judgment, we're trying to collect, we might send a writ of garnishment to the employer to put a freeze on 25% of that money, and then we have a claim of exemption that's filed. And so we're at a hearing and we have to determine whether the wages are protected or not. Sometimes what we have is a scenario where you have a husband and a wife, and they're both making money and they're both employed, and maybe they're both making similar amounts of money. And the question is, who is the head of a family? You can't have the husband and the wife who's the head of a family. There would only be one. So one of the ways that one of the things we look to is who's making more money. You know, who is making more money and appears to be the one who is paying most of the bills of the family or the children. But what about this? In a couple of those cases, I'll give you just the short facts. They're very basic. In one of the cases, I think the wife was making $2,300 every 2 weeks, and the husband was making $2,200. It was almost the same. And the question was, who is going to be the head of a family for the purposes of protecting wages from being exempt? And the bankruptcy court ruled that none of them are. Nobody's the head of a family. And that's the point for the takeaway on this page, that we can have scenarios where no one is the head of a family. And the way you'll know that is by looking at the comparative income of the two. In one of the other cases that we have here, we have one where the husband was making about $50,000 a year, and the wife was making about $51,000 a year. And the husband had filed a bankruptcy, and they were looking to determine whether his, whether he was the head of a family and his wages would be exempt. And it turns out the judge ruled that there's no head of a family here. And the reason is they focused on the term dependency. To be a head of a family, you have to provide 50% of the support for a dependent. And that means what it says. That person has to be a dependent. If it's a spouse and the spouse is employed and they're making good money, they can support themselves. And that's what the judge said, that this spouse could go out and completely sustain herself without the income of her husband, and therefore they're both going to be, neither of them are going to be exempt. All right, let's move on to the next page. Tenants by the entireties. All right, tenants by the entireties is, most of us are familiar with that term, and it's just a form of ownership in property. When a judgment debtor or any of us own property, there are different ways that we can own it. We might just own it in our individual name. We might own it jointly with a friend, a property we might be working on to build and improve and resell, or there might be something that we own with our a daughter or son, a bank account, or there are items of property, bank accounts, vehicles, real estate that can be titled to a husband and a wife. Tenants by the entirety is a type of ownership. It's a type of ownership that is only available to a husband and a wife. It technically is not an exemption, but it acts the same way, so I included it in the review material. Basically, the rule is this: if a judgment creditor has a judgment against a spouse, say a husband, and that husband owns property with his wife in a tenants by the entirety, that property is protected and cannot be seized. So it's just one of those things that gives a blank and total exemption to a debtor if they have their property owned in that manner. So what we do is we start looking for exceptions. In order to understand the tenants by the entirety and how that can protect assets or not, we look at the property itself that we might be looking to seize. And if you see the common assets, real estate, vehicles, and bank accounts, those are the ones we most often seize here. So let's look at how the tenants by the entirety operates with regard to specific property. Real estate. If a judgment debtor owns real estate and it's owned in the name of himself and his wife, it is presumed tenants by the entirety. It will be protected. We cannot seize it. Now, this tenants by the entirety wouldn't be necessary as an exemption if the debtors own a home, because there already is an exemption on that, the homestead exemption. But if a husband and a wife own rental property, now we're coming into a situation where if a creditor has a judgment against just one of the spouses, the creditor will not be able to lien the property or seize it because the rental property is owned as tenants by the entirety by the husband and the wife. So real estate is one of the ones that is very difficult for us to get to whenever it's jointly owned by a husband and a wife. Vehicles has its own rules, and it's pretty basic. In Florida, we do seize vehicles, and we like to take vehicles in this office and also put liens on them. Florida has a statute that allows us to put a lien on a debtor's vehicle for the amount of the judgment. And it's pretty effective. Nothing works all the time, but in terms of it being a hassle for a debtor, it is. I had a case years ago against a lawyer, and he had just bought a truck for $100 and some odd thousand, and he put almost nothing down, so he had no equity in it. And I had a judgment against him for a creditor for $40,000. So I filed a lien against his truck. He retained an attorney, and the attorney called me and said, "Tom, my client is asking if you lost your mind. Why would you put a lien for $40,000 on a truck that already has a lien on it for $100,000 and won't have equity for probably 3, 4, 5 years or more?" And I knew the attorney. Said, "You know why?" I said, "Because he doesn't want to be driving around a truck and know that he's got a $40,000 second mortgage on it." And he ended up paying the judgment. So it isn't about whether or not there's equity in the vehicle. Sometimes it's about whether you can put that lien on the vehicle and let them know that it's always going to be there. They will never have full ownership of the vehicle because they will never be able to sell it if there's a lien on it, and they will never be able to trade it in. All right, let's stay with this. Next, we have let's stay on that page if we can. I want to talk about bank accounts. This was page 17. Okay, with regard to the bank accounts in tenants by the entirety, we have a different rule that applies, and this one is important to note. With bank accounts, we have a statute that says if a creditor goes to freeze that bank account, the bank account is going to be exempt if it's in the name of a husband and wife. It's going to be presumed that way. So how do we get past that? The way we get past it is that we try to find out if there's an exception in the paperwork, the signature documents that were signed by the debtor at the time they opened the account. So whenever we freeze a bank account, and it's in the name of a husband and a wife, but the judgment is only against one of the spouses, the key is going to be getting a copy of the account card that the debtor signed when they opened the account. And here's why. What happens is that some of these banks have different little blocks that you can check off. And if there was a block to check off that said tenants by the entirety, and they did not check it off, the account is not going to be protected as tenants by the entirety. It's as if they intentionally chose not to have a tenants by the entirety. And what happened was that case was taken to the next level in the Story Mountain case, where a creditor came and froze a bank account that was in the name of a husband and wife, but the judgment was only against the husband. And the account card didn't have anything about tenants by the entirety, but it incorporated by reference other paperwork to other terms and conditions. And the creditor in that case, the attorney, was a smart guy or gal, and he got those documents, those terms and conditions, and who would have thought? The terms and conditions had a provision in there that says this bank doesn't do tenants by the entirety's accounts. And he made a nice collection in that case. So, so that's our tenants by the entirety. All right. I've been chatting a lot. Does anybody have any questions? If you do, you're welcome to pass them along and I will see it. And while they're doing that, we'll move on to page 19. We've sort of covered some. All right, page 19 just talks about the exceptions to the tenants by the entirety. If you have a judgment against both the husband and wife and you're freezing a bank account, you're still going to be able to get it. If the car's in both names and you have a judgment against both the husband and wife, you'll be able to seize the asset. Federal taxes, they have a way of getting around some of the tenants by the entireties. So if a debtor doesn't pay their taxes, they may end up even having some of their joint property seized. Also death of a spouse. I've had cases where they're older and we monitor for that, because as soon as one spouse passes away, all the assets that they jointly owned would then become available for seizure by a judgment creditor of the surviving spouse. So divorce can alter the tenants by the TBE protection. And also the bank documents, we've already talked about that. All right, let's move on to the next. We're doing good here. All right, we talked about this some already. This is a little bit more detail. This is about the claim of exemptions that we have in court. Just a reminder that when we do a garnishment of a bank account and the debtor says, wait, I'm the head of a family, there are certain ways of tracing the money in the account to determine whether it can be traced to exempt assets. Now, because what can happen is you can have different kinds of money in a bank account. There might be wages, or in this case with Hancock and Adams, there was wages in the account that were frozen. There was unemployment compensation that was frozen. There was retirement benefits that were frozen. And then there was some IRS refund proceeds that were in that account. And I like this case because the judge made a mistake and he was reversed. And it's a mistake that's made by many judges. And I've seen judges make this mistake in person. They're at a claim of exemption hearing. The bank account is frozen and the judge is focusing on whether the debtor is the head of a family. So the debtor comes in and testifies and says, hey, I've got 4 kids and I got a wife that's unemployed and they froze my bank account, and I want to have it released. I'm the head of a family. Well, that's correct. If you're a head of a family, you cannot seize money that has been deposited in that bank account, or even wages, you can't get to them. But still, the judge has to do a review of the money in the bank account to trace it to wages. They have to figure out how much of the money in the bank account is wages and where the other money came from. Because it might be that, okay, their wages are exempt, but other money is not exempt. For instance, in this case, we have an IRS refund. Those are not exempt in Florida. Now, in this case, the debtor had all of these monies in the bank account, these different types of funds. The judge just looked at the fact that the debtor was a head of a family and said, I'm exempting all of these monies. And he even made the mistake of stating on the record that the debtor was having financial troubles or struggling and really needs the money anyway. What a mistake. There is no exemption in Florida for hardship. Yes, these debtors sometimes can be going through hardship, and the judges will review the exemptions favorably in the debtor's benefit, but the judges are still required to go through the account and determine each fund of money that's in the account and decide what part of those monies are exempt and what parts are not. In this case, the judge didn't do it. He just said it's all exempt because of the head of a family. But that's not the issue. The question is whether the head of a family and whether the money in the bank account is traceable to an exempt asset. Wages would be exempt. Unemployment compensation, there'd be an issue there, but it normally is exempt. Unemployment is exempt. Retirement and profit sharing might be something we can get to. There's case law that says you can do that. IRS refund, you could get to it. All right, so the important takeaway here is just the reminder that when there's a claim of exemption hearing, it's not just about whether someone is the head of a family. All right, let's move on to the next page, which will be page 23. All right, we're at 11:47. We're going to end up on time today at 12 o'clock. Again, happy to have any questions. If not, I'm just going to march on here. The title of this is What Qualifies as Wages Under Florida Law. This comes up in a very common issue, again, with regard to garnishments of bank accounts. When we garnish a bank account, or if we do a wage garnishment of the debtor's wages, we're not just looking at a head of a family anymore. We're looking at the quality of the money that the debtor is receiving. What is it? Is it wages, or could it be some other type of compensation that could be garnished? The only thing that's garnishable in Florida under the continuing wage garnishment statute is wages, which they define as earnings. Now, you would think that would be easy to figure out, and 98% of the time it is, but not always. And that leads us to the exceptions, which is where we collect money on the exceptions. If they're wages and the debtor's receiving money from W-2 income, whether it's salary, W-2, commissions on a W-2, or bonuses that they get on their paycheck, it's all going to be wages or earnings. And those would all be, could be essentially exempt except for the 25% that we would get if the debtor is not the head of a family. But you've got these issues where there's a question as to whether they're wages or whether there's something else. So we'll move on to the next page, where we'll get into that a little bit more, page 24. All right, this is where we're looking at the difference in the type of pay that a debtor receives. We know that debtors anybody can be paid on a W-2, or they can be independent contractors. The independent contractor problem, I'll call it, comes up routinely with realtors. We have a hard time collecting from realtors in Florida because in Florida, there is no continuing wage garnishment against independent contractors. The only continuing garnishment that we have in Florida is for wages. So there are no wage garnishments for a realtor. Or if you have a salesperson who is paid as on a 1099 and not a W-2, they're going to be an independent contractor. What that means essentially is that the money that's being paid to this person is not wages, and it cannot be attached with a wage garnishment. And so we have to look closely at that. Now, there's different ways of getting at it. a regular garnishment can hit some of those independent contractor monies. But the point here for us is sometimes we have to distinguish between W-2 money and independent contractor money. This comes up a lot with DBA situations. You've got an individual that owns a business, but it's in his own name. What happens if the judgment creditor freezes the bank account of that individual and his business? And the business account, say it has $50,000 in it. And some of the money might be earmarked for taxes. Some might be earmarked to pay vendors. Some might be earmarked to pay the employees. And some might be earmarked to pay the owner of the company. I've had a number of these cases, and most collection lawyers have, where we file a garnishment of a bank account. It's a DBA account, and the individual files a claim of exemption, says, I'm a head of a family, the money is exempt. Well, here's the trick here. The debtor owner of the business can be the head of a family, but that's not going to solve the problem. You can be the head of a family, but the money still not be exempt. And in this case, the money would not be exempt because DBA money is not exempt. It's business money. So that one case there, Vining v. Siegel, I've used it many times, basically just says that DBA accounts are available for seizure. This has also come up in other ways with attorneys. I believe the McDermott case may have been that attorney case, but essentially we had an attorney who does work on a contingency basis. He settled a case and he has money in his trust account. And then he transfers that trust money to his operating account. Now he has all this money in his operating account from which he was going to take a paycheck. Well, the operating account gets garnished because there's a judgment against the attorney individually, and he has this in his name individually. The courts have ruled that that is not wages. They haven't taken the wages yet. A paycheck hasn't been uttered yet. It's just sitting in a bank account. So it is not wages, and it's fully available for garnishment. So whenever you have a case that's against a DBA and you have a bank account to freeze, there's a good chance that you'll be able to get all that money in the bank account, irrespective of wage issues. All right, let's move on to the next one, which is unemployment benefits. Unemployment benefits aren't something we would garnish. I mean, normally no employer would want to do that or take a debtor's unemployment benefits, but it's worth at least knowing because we have a case here, came out of federal court where a debtor filed bankruptcy and he had a bank account with about $15,000 in it, and it all came from unemployment benefits. And the debtor said he filed bankruptcy, but he wanted to keep his $15,000 because it was exempt under Florida rules. And of course, when I mentioned bankruptcy cases, bankruptcy judges look to Florida law for those decisions. So in this case, the money that was in the bank account, it didn't work. It was, let me see, it was automatically protected, except that the judges looked to the statute, and they made a really harsh decision. They reviewed it very literally and ultimately came up with a conclusion that unemployment benefits are not exempt in Florida once they're deposited into a bank account. Now, it's not like many attorneys would be, or many creditors would want to take somebody's unemployment benefits, but if they're surviving fine and paying all their bills and they have $15,000, $20,000 in the bank account in unemployment benefits, it can be seized, and there's case law that supports that. All right, next. IRS refunds, we can cover that in about 30 seconds. You can get IRS refunds. There was a time at which some people thought that IRS refunds were the same as wages and that they would be exempt, but cases came out and all said the same thing. IRS refunds are not wages. So if a debtor receives his IRS refund, and we collection lawyers are fortunate enough to have frozen the bank account with the refund money in it, it's not going to be exempt, and the creditor will be able to take that. All right, we're wrapping up here a little bit. I'll just talk here for a minute about death benefits, life insurance policies. We'll just talk about a situation that I had. I had a woman that was referred to me, and she was a debtor. This was years ago, back when I did some debtor representation, and she was being sued. She had a judgment against her, and what had happened was her husband had passed away. And when he passed away, he had a life insurance policy with a $300 a value that was paid to her, and it was in her bank account. So she came to me saying, what should I do? This creditor's coming after her. She has $300,000. And, initially you would think, well, it's life insurance. It's protected, right? There's a statute right on point. Life insurance beneficiaries, life insurance proceeds are protected. Well, it turns out those monies were not protected. We ended up getting the case resolved, but the short summary of life insurance proceeds is that, and if you ever have a situation where you're determining whether you can take life insurance proceeds from someone that might be in a bank account, spend a few minutes and look through this seminar materials, read a couple of the cases. It has to be analyzed closely. The insurance policy has to be in the name of both of the debtor, and he has to be the insured. So in other words, the owner of the policy has to be the insured on the policy for there to be an exemption of the money. But if the beneficiary is someone else out there and that beneficiary has a judgment against them, the creditor can still take the life insurance proceeds. So we'll just sum up. Exemptions in Florida aren't always what they seem to be. They're out there, debtors assert them, and sometimes we talk about these exemptions and people wonder, wow, how do you ever collect money in Florida, Tom? Well, we do, and we collect plenty of money. Many of these garnishments that we do, even if we don't collect, makes them uncomfortable. And some of these people will work out payment arrangements because they don't want someone to freeze their bank account, even if there was only $50 in the account. They don't like that type of activity. So the efforts to seize assets, even if it turns out they're exempt, alone can be of some value. But in Florida, there are plenty of exemptions. But if you just look through the headlines and get the essence of it, the attorney will miss what really can help them collect on their judgments. There are exceptions. They're not always easy to find, but they exist out there. And for the smart and aggressive collection lawyer, it's important to understand all the exemptions and also understand all the exceptions to those exemptions. Okay, I've enjoyed this seminar. I hope you guys have gotten something out of it. Let me wrap up a little bit and mention a couple things. All right, first, if you submitted a question, we didn't get to it, I will respond to you later. Happy to send you an email. Be sure to follow on social media for more information, webinar dates, LinkedIn, Facebook, TikTok, etc. And also remember, we've got another episode coming up in August. It's going to be a good one from what I'm told, and I'm looking forward to seeing that one myself. You also have my email. If you have a question that comes up in this area, I enjoy this. I've been doing this for a long time, still doing it. Don't plan on going anywhere. I'm happy to talk about any issues that you have. So if you have some or questions or you want a copy of some of the paperwork, just email me. I'll be happy to send it to you. All right, that'll be it for me. Madison, is there anything else that you have to close this out?
No, you're good to go.
All right, thank you, everyone. I appreciate it, enjoyed it. Hope you got something out of it. And I look forward to hearing from you if you have questions.